Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. This week we're talking immigration, employment, and enforcement. And joining me today, first, Michael Patrick is a partner with Fragaman, Delray, Bernson, and Lowy. Hope I got that right.
Delighted to be here.
Next to you is Patrick Shen, who is the Director of Global Compliance, also at Fragaman, Delray, Bernson, and Lowy.
Hi, Chip.
And Jacqueline Wolf, who is a partner with Manat, Phelps, and Phillips. Thank you all for being here today. And we are going to talk about something that is really on a lot of people's mind these days, not just employment, but the issue of immigration and what do you have to do as an employer. First, let's start with the basics. Michael, it happens hundreds of thousands of times every week across America, and probably we would all hope it happens some more, and that is somebody gets hired. When someone gets hired in the United States, what is the first thing an employer must do?
From an immigration perspective, what an employer must do is be sure to complete what is called the Form I, capital I-9. And that form is a two-part form where the new employee fills out Section 1 and then the employer fills out Section 2. The Section 1 has to be filled out at or before the time the person starts work, and Section 2 is going to be filled out within 3 days after the person started, although many employers have it all done the first day the person starts. Section 1 asks the employee to give information about where they live, who they are, and whether or not they are a citizen of the United States, whether or not they are here on a green card, that is a lawful permanent resident, or whether they're here because they're authorized to work. And then they sign attesting to the truthfulness of that, and under penalty of perjury, so if it turns out they're not telling the truth, the government could prosecute them for making a false statement. Then the employer has to fill out Section 2, where the employer asks the employee, the new employee, to produce documents which are chosen by the employee off a list of options that indicate whether the employee is authorized to work and who they are. It could be one document, like a green card might be, or a U.S. passport, or it could be two documents, like a driver's license and a Social Security card. The employer records that information. Sometimes the employer will photocopy. If they do that, they have to do it for all new hires, and then return the originals to the new hire. The employer signs that they've done this, that they looked at the person, that they made sure the person in front of them matched the documents that they have, and then the document gets filed away and kept by the employer and stays there until the employer can either toss it away because the employee has left and has left for enough period of time so you can toss it away, or until the government asks for it, in which case you have to turn it over.
So on that point, Patrick, so you fill out the I-9 with the information you received from the employee, and you basically put that in a file. You don't have to turn that over to anybody. You're not sending that in to anyone. The only time you would be required to have that file examined is if the government comes in and says, let us look at your I-9 files, correct?
That is correct, Chip. And you raise an important point there, which is that even though this form is not submitted to anyone, it's very important for the employer to make sure that the form is in compliance with regulation, because once the government agents show up, there would be consequences for noncompliance.
And this law has, I mean, this is not something new. The I-9 requirement has been in law since, I guess, the mid-'80s, correct?
That's correct. It was actually part of the 1986 Act. Many refer to that act as the 86 amnesty because that was the biggest piece of that legislation. But as part of the 86, what's called the Immigration Reform and Control Act, employers for the very first time became liable for verifying the work authorization of its employees.
And so that the 86 Act was, of course, during the Reagan administration. Then there was another major act, I guess, in '96, wasn't there, under the Clinton administration? And there really hasn't been any major change since then.
There's been little tweaks to extend certain programs. So you're right; those are the two biggest legislative events involving worksite enforcement and verification of employment authorization.
Let me go to you, Jacqueline. Anytime that you are dealing with an employee in any type of official capacity, and you're asking for documentation. As an employer, what are the things, and in this case we're talking about filling out the I-9 form, but what are the things that you need to make sure you do and the things you need to make sure you don't do?
Well, I guess there's so many different competing interests when you fill this out. One is, and I know Pat can speak to this in detail, there are discrimination provisions you got to be careful about. There's certain questions you're not supposed to ask because that would be construed as discrimination. On the other hand, you have to be somewhat thorough because you don't want to be put in a position that you're taking a card, for example, as Michael mentioned, a card that on its face doesn't look so good. In fact, it looks bad. It looks like it's probably a counterfeit document, and then not ask any questions about that and say, oh, this looks fine, and fill it out. And because down the road, if the government does come and look at your I-9s and looks at what you've accepted, if it's something that is clearly on its face not valid, the government could construe that as you're having knowledge, or constructive knowledge at the very least, of that person not being authorized to work, which would be a problem because then you're getting into the criminal arena.
And Michael, let's touch on that for a moment. So if I'm an employer, there are questions I don't want to ask. I don't want to go too far, but by the same token, if I were to walk in and you were my employer and I'm obviously a white male and I hand you an ID card with a photograph of an African American female, that would be a problem.
Oh, that would be a problem per se. That's
Right.
that is without a doubt a problem. There's no way an employer could explain that I thought that
Right.
that person was the person on the card. But the fact is that once you get away from the, pardon the pun, black and white contrasts,
Right.
it's not always easy
Right.
because sometimes people do look alike. And it's possible that an employer thinks that the person on the document is indeed the person in front of them, and they're not. And when the government comes back later and says, you should have known, the employer goes, it looked good to me, that becomes very subjective. And a lot of employers have been upset with the government's sometimes rigid approach to this. The legislative solution, which Patrick can certainly talk about, has to do with, well, why don't we take discretion out of the process and create a system so that it's not the opinion of the employer whether the person matches the document, but there's a biometric connection between the document and the person, like a fingerprint, for example. Right. So it's not the employer's discretionary determination.
Patrick, talk about that for a minute. Are we headed that way? I mean, I know there's a lot of people who get very uptight when you start talking about any type of national ID card, and as you pointed out, Michael, biometrics. I mean, people get a little scary with that, and I mean, it's just been since 1986 that you even had to fill out an I-9 form. But are we now to the point where you're going to have to give your thumbprint or a digital photograph just to be eligible to work?
Well, Chip, I think it may be overstating a little bit for me to say that we're headed that way, but there's certainly been a lot of discussion because without a question, as Michael mentioned, identity fraud is a problem. It's not only a problem for law enforcement, it's a problem for employers because the employers who want to do the right thing have no idea if the person standing in front of them is who he or she purports to be. So among the legislative proposals are expansion of the current what's called EVerify, which I know you go into later, and also there's currently a bill introduced by Lamar Smith, the chairman of the House Judiciary Committee, which would call for a biometric pilot program to test it out and see how it would go. You're absolutely right. Every time we talk about what's called a hardened Social Security card with security features or national ID or biometrics, you have the left and the right coming together opposing it from the
that doesn't happen often, by the way.
No, it doesn't, but it happens on this issue quite a bit. And that's quite a formidable political force against whoever is trying to push that through.
But you forgot as well, Patrick, that another component of the problem with identification capturing is the victim, the person whose
Right.
identification is being used. And we've built a system now which really incents people to steal IDs. I steal IDs from any of the four of us or anyone else,
Right.
and that's not a smart system. So somewhere in there, I believe the people in Congress who are paying attention to immigration, including Chairman Smith in the House and Senator Schumer in the United States Senate, my sense is that they understand that an employment verification system in the United States is not going to ever work the way it needs to work until there is subjectivity and discretion removed from the employer.
Right.
And if you want to call it a national ID card, or you want to call it a hard Social Security card, you want to call it call it what you want. Until it's removed, it will never work effectively.
You're absolutely right, Michael. You're absolutely right, Michael. I think this is an issue where there's bipartisan support and bipartisan opposition.
Strange days indeed. We've touched on, and I think you mentioned the term EVerify, and I want to talk more about that in the second half of the show, and we'll do that coming up right after this. Welcome back, Chip Rogers with the AAHOA Educational Experience. Again, we're talking about immigration, employment, and enforcement. First half of the show, we talked about the I-9 form, and that has been the requirement now for 25 years. You're newly hired. Your employer must fill out the I-9 form, which takes documents from you proving that you are legally eligible to work. There's another program that is in place now called the EVerify program, and I'll talk about that in just a minute. But from an employer standpoint, Jacqueline, the time frame. So I hire someone, how long do I have before I have to fill out that I-9 form? I can't wait until someday and the feds show up at my door and then start filling out I-9 forms. I have a certain time frame in which I have to do that, correct?
I believe so. I think that Michael and Pat can probably answer a little bit better than I can. I believe it's 3 days, but you guys can.
Section 1 is the honor before the day of employment, and
Yeah.
Section 3 is within 3 days. Section 2 is within 3 days.
Okay.
So, but from a penalty standpoint, if I fail to do some of these things, civil, criminal, what do I have to worry about?
Well, yeah. I mean, my practice is really from a criminal standpoint, and I don't know what the particular civil penalties might be involved, but generally, from a criminal standpoint, when a U.S. Attorney's Office is looking at an employer and seeing whether or not they have knowingly engaged in a pattern or practice of hiring unauthorized workers or even harboring unauthorized folks, and sometimes harboring and employment can overlap, they will look at the I-9s first. It's the first thing they'll generally ask for. And they'll see, number one, have they been filled out? If you've got, for example, your legal workforce filling out I-9s and your unauthorized workforce, you haven't filled out I-9s, that would be evidence of knowledge. So you can't not fill them out, regardless of who your workforce is.
Right.
Because should you have certain workers, unbeknownst to you, that are not authorized to work, but they brought in documentation that looks good, and you filled out the I-9, you're in much better shape, obviously, than if you don't fill those out, because the jump from the government will be, and the assumption will be, you must know they're not authorized to work, otherwise you would have filled out an I-9 for them.
But Jacqueline, wouldn't you agree, not that there are employers that would ever do this, that if an employer fills out an I-9 knowing that it's false, that's a worse position than simply not filling out the I-9?
It's worse in that there might be more available statutes
To
for
the
the
U.S.
government to
Attorney's
use.
Office, correct.
Right, the U.S. Attorney's Office can do some false statement statutes and some more interesting additional statutes to the immigration laws, but in terms of whether or not you've committed a crime, I'm not sure there's much of a difference in terms of the knowledge element. And I think, what we're talking about here, you realize that the biggest burden of all of this falls on the smaller employer. Because the smaller employer, let's say somebody comes in, very often, first of all, fellow employees or supervisors are going to know the applicants. That's the starting situation. It's not as if you're a giant Fortune 500 company and you have no idea who your employees are. This is a situation where, number one, you might even know the applicant because they might be related to someone, number one. Number two, you might have a situation where somebody comes in and they get friendly with some other employees and you only have 50 employees. And they get to know that the other person who confides in them really is not authorized to work. So now you've filled out everything properly on your I-9s. And a lot of employers get a little confused about this. They think, well, I did everything I was supposed to do. I know there are anti-discrimination laws. I'm not allowed to ask questions of the applicant. But now I've got this other information that's been provided to me that indicates this person might not be authorized to work. What am I supposed to do? And that kicks in a lot of things, because you can't just sit there quietly and say, gee, I did everything I had to do. I'm not going to ask. It's sort of like don't ask, don't tell doesn't work there.
I would concur that that is the common scenario, not the huge mega corporation.
Right.
Right.
That is the American employer, typically mid to small size, and they're the ones that are having the most difficulty, and they're the ones that essentially are also being targeted.
And I want to follow up on that, because many years ago there was a program created. I believe it started known as the Basic Pilot Program, and then after many years that Basic Pilot turned into what is now known as EVerify. And I think it was the government's attempt to say, look, we want to take the false document out of play here and require that people be electronically verified. Michael, explain to us EVerify and how does it work, and is it working?
Well, the concept of EVerify is that we have data somewhere that can tell us whether or not that person is indeed authorized to work because they are either authorized incident to status, meaning they're a citizen of the United States, or they have a green card, which means because they are that type of person, they're allowed to work because of that class. Or they came here as the spouse of someone who is working professionally, and they're on a visa that allows them, as the spouse, to go get work authorization. So they got that work authorization. It's temporary, it will expire in 2 years, but they got it. Somewhere there's a database that should tell us that. So the concept of EVerify is there's got to be a way to match the data sitting in these databases with the person who's standing in front of you. Well, that's a lot easier said than done, because you're talking about hundreds of millions of points of data. You're talking about situations where the data is not sitting in one place. But Congress got smart, the immigration authorities got smart, and so we've got to start somewhere. Why don't we start with the immigration database? After all, that's the place that gave the authorization on the employment card. And how about starting with the green cards? We've got to know those people. It's the citizens that has difficulty, because there you get to the national database. And Social Security says, well, we have a database, but one of the problems is for years and years and years, people got Social Security numbers without having to show that they were citizens. So we have not a full mix and match, but we have a system that's not too bad. The concept's not a bad system. Civil libertarians, holders of the American Civil Liberties card like myself, get nervous, you said it earlier, get scared about the idea of Big Brother holding all this data and having verification occur. On the other hand, without it, we're never going to have the type of tight system that will allow this to work. So right now, the EVerify is a concept that says we're going to match that centralized data with the information sent in, and it's all done electronically. It's not like the telephone. The data is sent in electronically, and if it's a match, the employer is told, and the person continues to work. If it's not a match, the person still keeps working while we try to figure out the problem.
And Patrick, how prevalent is it? I mean, the plan's been around a while. Basic pilot started with just a few states. It was expanded, and up until recently, it was a completely voluntary program, and it still maintains as a voluntary program at the federal level, I think, except for contractors.
Correct.
But now there's a dozen states or so who have said that it's going to be mandated by state law. So how many employers are now using this? And just to follow up a little bit, I mean, is it getting better? Is it working better?
Well, we have certainly been following the system and its improvement over the years. I would agree with what Michael says, that the concept is one that's needed, and it's gotten to a point where I think it's very good at what it's intended to do, which is to match a name with a number. As far as the growth of the program, a 2005 Government Accountability Office, a GAO study, showed that there was only about 2,300 active users in EVerify. That number I checked about 2 weeks ago is up to about 270,000. So it's increased quite a bit, and in part, of course, is the system itself becoming more reliable and employers having more confidence in the program. Another one is some employers, those voluntary, like the safe harbor, because if you use EVerify, you rely on the government's data, and there's something's wrong with the person's work authorization, there's a logical defense there. But I think, as you mentioned, Chip, for the most part, I think the increase comes from the various states mandating usage as a condition of doing business, either in or with that state, and the federal the amendments to the federal acquisition regulation, which mandates certain, not all, but a lot of federal contractors to use the program.
But there are 7 million employers in the United States, so we have a long way to go.
Still talking about 3% of the whole employer population.
I believe there's legislation that deals with that, which we'll talk about in another show.
There's another piece, Chip, that I wanted to stress with EVerify is that it's a great idea, and again, it works. It's something that works better in a big company than it does in a smaller company, because you can't rely on it as a safe harbor, as Pat was saying before, in some ways. If it's a small company, and in spite of the fact that someone's gone through EVerify, the people there know that, in fact, that's not who they say they are. So they've bought somebody's identity, which is not a good thing. And they've used it, and they've sort of sailed through EVerify because they have a legitimate social, goes with a legitimate name, but happens not to be theirs.
And that's a really important point to point out with EVerify, because the employer is simply taking a name and taking a number, putting it into the system, and it either comes back, yes, that name and number match, or no, that name and number do not match.
Right.
But it doesn't say whether that name and number belongs to that person.
Exactly.
So does the employer have the responsibility, even when using EVerify, to take that second step, as we talked about with the I-9, to say, Well, this ID with this name and number, it reasonably matches that person. Do they still have that responsibility?
Oh, I believe so.
Oh,
I
absolutely.
believe so.
Absolutely. The employer needs to confirm the document or documents being presented match the person. And in a perfect world, the EVerify system would produce a picture of the person from that centralized database, which it started to do in very limited circumstances.
Right.
So for example, we have a photo of the person who got the green card.
Right.
So now the employer gets that photo streamed to them by the government, and they're supposed to look and see if it matches the person standing in front of them. The problem is it's a very small pool of people that we have photos for.
Right, because U.S. citizens with
Right.
just getting a
Right.
Social Security number are not going to be photographed.
That's
Well,
correct.
except for those holding a Mississippi driver's license. So if I were an unauthorized worker and I'm out in the market to buy a fake driver's license, I'll be sure to avoid, of course, Mississippi. But that opens me up to possibilities in all the other jurisdictions still.
All right. Well, we are out of time. This has been great. We've got a lot more to talk about in upcoming shows. So for my guest this week, Jacqueline Wolf and Patrick Shen and Michael Patrick, thank you for being with us. That's it for the AAHOA Educational Experience. Please join us again next week.